Hi, everyone. Thank you for joining us today. I am Tommy. I am a partner of Hogan Lovells Hong Kong office, and I'll be acting as your moderator today, and also share a few thoughts later. I can see from the attendee list there are many familiar names, so welcome you. For those of you who we know, welcome back. With those of you we have never met, we don't know each other. It's a very pleasure to meet you all. On behalf of the Hogan Lovells APAC team, it's a pleasure to be here to be sharing key updates and implications for data privacy and cybersecurity in 2025 in the region. As a quick introduction on the agenda, we will share thoughts on North APAC, including Mainland China, Hong Kong, South Korea, and Japan. Then we'll fly south to dive into South APAC, providing updates for Singapore, Indonesia, Vietnam, India, and also Australia. For those of you who are based in Hong Kong, it's our pleasure and happy to let you know that Hong Kong Law Society CPD accreditation has been applied for. So there will be CPD points for the session. Please ensure you stay for the whole hour so we can apply for your CPD points. The Hong Kong Law Society is approving our CPD application, but we don't expect any issues. Next slide, please. I will briefly introduce our speakers today. I am Tommy, as mentioned. I'm based in Hong Kong. You also have Charmian, is based our Singapore office, and Sherry from Beijing office, Duong from our Hanoi office, and Andera from Jakarta office, and Maria from our Tokyo office. I will have each of the speakers to briefly introduce themselves with their sessions. Next slide, please. As you have already been aware of, our APAC Data Privacy and Cybersecurity Guide is an annual release. For this year's release, same as before, we're covering jurisdictions for North APAC and South APAC. For those of you who have not downloaded the guide, there's a QR code at the bottom, so you can scan and download and have a read. And here is the map. Here is a heat map that we have prepared for each of the markets in APAC from a regulatory enforcement perspective. Next slide, please. First of all, I will have Sherry from our Beijing office to share sessions and share her thoughts on Mainland China. Sherry, please.
Thank you, Tommy. Hello, everyone. I'm Sherry Gong. I'm a partner of Hogan Lovells based in Beijing office. My practice area focusing on data privacy, cybersecurity, and technology in general. I'm very happy having this opportunity to go through the highlights of the China data privacy and cybersecurity developments in the last year and in this year. As you know, since 2024, China relaxed the cross-border data transfer regime, and we have some positive numbers here. According to the CAC, actually there are 90% security assessment applications has been approved. And among the 10% failure, the major reason for failure is because the companies do not have the appropriate individual consent for the cross-border data transfer. And 20% is because it's transfer important data outside China, but not have a good ground or justification for that transfer. Also, other reasons is because the company do not offer the sufficient security. And we also see there are some successful cases for cross-border transfer of important data. However, the failure rate is a little bit higher. It's about 15.9% because it's hard to justify why the companies need to transfer important data outside China. And we also see some developments in the clarification about the exemption rules. Even it's not in the official document. The CAC identified that some, like for exemption for performance of contracts with related individuals, the company cannot argue it's for marketing purpose or it's for cost control purpose. is not justified for exemption. And for human resources management, normally like the HR employment matters can be fall under this exemption. However, if it's only for we want to get approval from headquarters, or we want to have the collaboration office work with our affiliates, they are not justified for the exemption. Next slide, please. Yeah, we also see a lot of legislative updates and the practice updates in China, including, as you see, the China authorities issue the guidelines for in the certification area that try to promote the certification as an alternative to the SEC and can be used as one of the 3 mechanisms for cross-border data transfer. And we also see the government take actions to streamline compliance for multiple national companies. For example, the CAC allows consolidated applications and filings of the security assessment or FCC's filing for multiple national companies. Also, we understand the CAC is intends to introduce a standardized certification framework, and then the multiple national companies can get benefit for the intergroup transfer. And we also see CAC is actually doing the sector-specific guidance. Is that the CAC is drafting guidelines for auto industry data exports. And as you know, since the first batch of the security assessment in 2022, they're almost 3 years. And the valid period will be expected soon. So the government is thinking offer a faster track renewal mechanism for the security assessment. So that's very positive sign. And we also see the negative list coordination is very popular right now. For example, we have Beijing free trade zone negative list, Tianjin, Shanghai, Hainan, and other free trade zones. And other provinces are also finalizing their negative list to offer some facilities and convenience for the companies to complete the cross-border data transfer regimes. And we also heard that the CAC is trying to build a nationwide integrated negative list. So there's a trend to offer more facilities for cross-border data transfer. And also for identification of important data, the authorities are also trying to build catalog guidelines in some areas like autonomous driving and the automotive industry. Next slide, please. We also see some compliance. In addition to the application enforcement, some like super accounts has been a focus of the government enforcement because the company do not have the appropriate access control. And also for entrusted data handlers, we see there are some oversights. Inadequate, the oversight is not sufficient. And also that response plans is not testified. Also for the deletion data retention is not very, complying with the law. So we see the enforcement in that area. And we also see some class, the additional obligations and new development in important data identification. The CAC clarifies even if the company has not been notified or has catalog for the important data, you don't need to go through the cross-border data regime for exportation important data. However, the company still need to do the classification of important data by itself in accordance with the guideline. Also, under the recent audit measures, the company is required to conduct regular and authority required audit. So the company needs to consider whether they process personal data more than 10 million. In that situation, the audit requirement is 2 years. If less than the threshold, then the company can decide the threshold. And in other situation, the audits will be triggered by the government. In that situation, the companies has to engage a professional institution to do the audit. We also have update for the facial recognition technology more stricter requirement in that regard. Because of the short time limit, I just stop here and hand over to Tommy for Hong Kong. Thank you.
Thank you, Sherry. I will now share some thoughts for Hong Kong. For those of you who are based in Hong Kong or based in the Greater China region, you may already be aware that Hong Kong's Personal Data Privacy Ordinance, the PDPO, was introduced in 1996. And there has been 2 rounds of amendments, major amendments, since the first one is back in 2012. It was primarily focusing on direct marketing controls. The second major amendment to the PDPO was in 2021. It is to include the offense of doxing, making it a criminal offense in Hong Kong. And we have seen in the past years, there have been major enforcement actions in Hong Kong on doxing issues. The PDPO is noticeably actually lagging slightly behind in developments internationally, and this has been aware of by the regulators. A discussion paper was presented in January 2020 outlining specific topics for reform, and proposals for reforms were planned and tabled in second quarter in 2023, but that did not come to pass. Earlier this year in February, the Privacy Commissioner has reported to the Legislative Council in Hong Kong that the comprehensive review of the PDPO was still ongoing. However, they have yet to work out a concrete plan and timetable to introduce the proposals for the legislative amendments. Next slide, please. As a brief recap of the proposed legislative changes in January 2020, the first one is a major one, is an interesting one, is the mandatory breach notification. It requires notification of data breaches having a real risk of harm, with considerations to be given to the time frame and the method of notification to both the PCPD and impacted subjects. This is not new, as a matter of fact, because a mandatory data breach notification has been implemented globally by many jurisdictions already, and Hong Kong is still considering to implement that and the best way forward. The second requirement, proposed requirement, is for data retention policy requirement. It basically requires data users, or we usually call data controllers, to develop clear personal data retention policies covering the maximum retention periods for different types of personal data. The legal requirements that may affect those retention periods and how the periods are calculated. We have, despite the non-mandatory requirements now, we have seen many MNCs and international companies have already adopted an internal data retention policy internally to ensure this aligns with the global practice. The third one is the increased level of fines and sanctions. The PCPD would propose increase the current level of fines and allowing the PCPD to issue administrative fines. Fourthly, there would be a proposed regulation of data processors. They propose to impose regulatory oversight directly over data processors, as well as the data users who determine the purpose of processing. Lastly, the definition of personal data is proposed to be expanded. The proposes to include data that relates to an identifiable natural person, as opposed to the current definition of identified natural persons. So this area of reform was not mentioned in the February 2023 legislative briefing. So we're not sure whether PCPD would push for this reform or not. Next slide, please. So the other aspects of a notable update in Hong Kong is the specific cybersecurity legislation. This is the first cybersecurity legislation in Hong Kong. This is called the Protection of Critical Infrastructure Computer System Ordinance. It's a long abbreviation called PCICSO. It was passed on the 19th of March 2020. It will take effect on 19th of March 2025. The objective is to strengthen the security of computer systems of critical infrastructures and minimize the chance of essential services being disrupted or compromised due to cyber attacks. This is a major improvement or step forward by Hong Kong on the cybersecurity side. We have seen many markets, many jurisdictions in APAC have already has similar cybersecurity laws, but Hong Kong has now finally enacted its own cybersecurity laws in Hong Kong. The regulatory framework established to empower the authorities to identify critical infrastructure, we call these CIs, which deliver essential services in 8 core sectors, including energy, information technology, banking and financial services, air, land, and maritime transport, healthcare, telecommunications, and broadcasting services. And those maintains important social and economical activities. There's also designated operators of such CI and their computer systems as critical computer systems. Next slide, please. The key obligations of the CI operators include organizational, preventive, and incident reporting responses. So shortly, in a short way, organizational perspective, the CI operators shall maintain office in Hong Kong, reporting operator change promptly, and maintain a computer system security and management unit. It shall also notify the authorities of significant changes to CCS, submitting security management plans, performing regular risk assessments and audits. Lastly, it shall also participate in security drills, submit emergency response plans, and notify authorities of security incidents in relation to CCS. We would expect the authorities will publish codes of practice or guidance notes in the future to clarify technical requirements and the implementation of PCI-CSO in the run-up to the PCI-CSO's effective date of January 1st, 2026. Next slide, please. Then I will briefly touch upon the latest developments in South Korea. As you're all aware, South Korea is one of the toughest jurisdictions for data protection and privacy compliance in APAC region. The rigorous approach to data protection is reflected in the European Commissioner's adoption of an adequate decision for South Korea in December 2021. The processing of personal data is governed by the Personal Information Protection Act. We all know that's a PIPA. Its requirements include the need to obtain separate, unbundled consents in a granular manner for a number of data collection and processing contexts. It also aims to provide to allow extensive transparency and disclosure requirements. Next slide, please. The PIPA underwent a major overhaul in March 2023 with changes to strengthen data subject rights by introducing a GDPR-inspired data portability right, integrate and update regulations on processing personal information by online offline data controllers, and also expanded cross-border data transfer basis for whitelist countries and certified companies. As of today, there is a new update to the PIPA recently, just after we finalized our APAC guide. On 1st of April 2025, the president of South Korea has signed, the acting president of South Korea has signed an amendment to the Personal Information Protection Act, PIPA, following its approval by the National Assembly on March 13, 2025. The amendment mandates foreign business operator processing personal information to establish a domestic corporation, appoint a local representative, and ensure oversight by the overseas headquarters. Domestic corporations are also required to oversee their local representatives and include these details in their personal information processing policies. This bill will take effect on October 2nd, 2025, and it will become law upon its signature and publication in Official Gazette. It aims to strengthen South Korea's domestic agent system and adjust personal data protection requirements for foreign entities operating in South Korea. Next slide, please. Then I'll pass on the microphone to my colleague in Japan.
Hi, thank you, Tommy. Hello, everyone. My name is Maria, and I'm Associate in Intellectual Property, Medical, and Technology team in the Tokyo office. I'd like to provide you with some updates regarding data and privacy and cybersecurity in Japan. As there are several updates, as you can see on the slide, but I would like to focus primarily on the significant new law, the Act on Cybersecurity Capability Enhancement, and then explain a bit about other updates. So I'll start with the Act on Cybersecurity Capability Enhancement. Could you move on to the next slide, please? Thank you. This new law has received considerable attention in Japan as it marks a significant shift in Japan's cybersecurity landscape. Previously, Japan's cybersecurity framework was primarily governed by the Cybersecurity Basic Law, which outlined the government's basic responsibility in promoting cybersecurity policies. Beyond this, only non-binding guidelines existed. However, just a month ago, the Diet passed this new act, which is expected to come into force by end of 2026. And this act introduces three main provisions. The first provision of the act concerns neutralizing cyber attacks. This law allows the police and the Japan Self-Defense Forces to take neutralization measures against cyber threats. However, this is mainly focused on protecting national and local government computers and those of critical infrastructure entities, and is not applicable to all private entities. Critical infrastructure entities refers to designated companies that are large-scale business entities, including electric power companies, transportation-related companies, banks, insurance, and other financial companies, credit card companies, and telecommunications companies. The second provision of the Act concerns strengthen government business-related partnership. The Act mandate the critical infrastructure entity assume incident report obligations. And furthermore, the government will share cyber attack information to business entities that are not limited to critical infrastructure entities. The third provision of the Act concerns the acquisition and analysis of telecommunication information, which is controversial. This enables the government to acquire communication information unrelated to cyber attacks and analyze it without obtaining consent from the entities involved under certain conditions. I will not discuss it in details, but communication information includes IP addresses and domains. However, the government is not able to acquire the content of communications, such as emails, attachments, and websites. And please note that this provision is applicable to information relating to the communication between Japanese and foreign companies. Now let's move on to other updates. Could you move on to the next slide, please? Okay, thank you. Cybersecurity guidelines were now issued for the financial sector, and these are aimed at banks, insurance companies, security firms, electric payment service, and cryptocurrency providers. Secondly, due to the amendment of various laws, medical institutions are now required to enhance their cybersecurity measures. And also, the medical device using computer networks are now obligated to take cybersecurity measures. Let's move on to the data protection. And the first point is that the amendment to the Personal Information Protection Act is currently under discussion. The actual draft of the amendment has not yet been reviewed and is expected to be announced soon. So we'll keep an eye on this as it develops. And secondly, the Act on Next Generation Healthcare Infrastructure has come into effect. I'll skip the details, but the law stipulates a regulation regarding patients' information anonymity. And thirdly, the amendment to the Information Distribution Platform Act has come into effect. And this law is aimed at preventing the spread of illegal and harmful information on the internet that infringes the right of others. And in short, this amendment requires large internet platforms such as Google and Meta to establish the deletion procedures for taking down potentially illegal malicious information. Lastly, the new AI Act, Promotion Act was passed by the Diet several weeks ago. This outlines the basic principle for development, AI development in Japan, and its impact on private companies is expected to be small. However, we will continue to keep an eye on this. For more details, please refer to the relevant articles that we will publish very soon. This concludes the Japan segment. I will pass it on to Charmian, who will walk us through the updates in Singapore and broader South APAC regions.
Thank you so much, Maria-san. It's really nice to be here. We are moving now to the south of APAC, starting with my home country, which is Singapore. So I think we could maybe talk about 4 areas of updates today. The first is AI. Singapore is an active champion of what we call AI governance. So unlike the EU, Japan, Korea, China, we're not really looking to pass standalone AI legislation per se, but that doesn't mean that there is no regulation of AI in Singapore. Rather, AI continues to be regulated by various laws pertaining to data protection, intellectual property, sectoral rules laid down by industry regulators, contract, tort, etc. And due to the prominence of data, I think, in the AI development lifecycle, Singapore's data protection regulator, which is the IMDA or PDPC for short, is very much taking the lead in driving the advancement of the country's policy objectives and regulatory initiatives in AI. Recent developments include advisory guidelines on the use of personal data in AI, as well as a synthetic data generation guide. Whilst neither is legally binding, they give practical guidance to businesses on how to comply with the PDPA when carrying out AI deployment or development. So with the synthetic data guide, for instance, we see the presentation of use cases, especially, for example, in the healthcare industry, where in lieu of personally identifiable information, which obviously poses greater harms and privacy risks to individuals, there is a use case for synthetic data being generated. And so it holds great promise for businesses in this space. Singapore has also adopted special lawful bases for processing personal data, which may be relevant or useful in the context of AI. These basically do away with the need for consent on the assumption that you have sufficient guardrails or conditions put in place. So first, we have this fairly unique business improvement exception to consent, and secondly, for certain specified research. Switching hats to enforcement in data protection, we have noted in the past year that Singapore continues, to be actively enforcing our data protection laws, and data breach reporting is mandatory in this country. And in fact, there is a prescribed list of data which, if compromised, automatically triggers compulsory notification to the regulator. This list includes things like an account identifier and password or access code. But with that said, what we saw and what we noted last year was a surge in what we call these voluntary undertakings that were accepted by the Commission in regards to data breaches that were reported. So what is this voluntary undertaking? Well, again, a fairly unique mechanism for Singapore that is essentially offered by an organization instead of or in place of a full regulatory investigation being carried out. So you report a breach. Instead of there being sort of a very costly and protracted regulatory investigation into that matter, you might offer a voluntary undertaking to say that you promise to do better in data protection. You might tweak, your third-party contracts. You might put in place more adequate or sufficient and robust measures of security, both technical, administrative, and maybe even physical. And if accepted by the Commission, that will do away with the full regulatory investigation. So we did a tally, and based on start of 2024 till today, we have 53 that have been accepted by the PDPC and published on its website. Turning to the third bucket, which is cybersecurity, again, Singapore is charging ahead with advancing this space. And a couple of things, we have very recently amended our Cybersecurity Act last year in 2024. We are still awaiting the sort of gazetting of when the commencement date of these amendments will kick in. But really, the remit of the law has now been expanded to cover more entities of potential cybersecurity concern. At the same time, we are also awaiting a separate digital infrastructure resilience law, which will cover cloud and data center providers operating in the ecosystem. Last but not least, Singapore has passed material amendments to strengthen regulatory oversight into what we call online safety. So this includes, imposing obligations on social media platforms who now have to moderate and take down certain infringing content, and app distribution services who must do the same with harmful material transmitted on apps that are available to Singapore users. And pretty much, I think we're constantly updating our regulatory posture to better protect vulnerable segments of the population, especially children. So with that, I'm going to hand it over to Andera to talk about Indonesia.
Thank you, Chairman, and hi, everyone. I'm Andera, an associate in litigation, arbitration, and employment practice group in our Jakarta office with a focus in data privacy and cybersecurity. And I will now discuss the recent developments in Indonesia's digital regulation landscape. The first one is relating to data protection. Indonesia enacted our first PDP law in October 2022 and heavily rely after the GDPR, and currently full in force as of October 2024, marking the expiry of the 2 years transitional period or sunset period. However, its effectiveness is constrained by institutional delays and uncertainties in enforcement. It is important to note that Indonesia currently has yet to establish the independent Personal Data Protection Agency as mandated under the law. But currently, the Ministry of Communications and Digital acts as interim regulator. And without the PDPA, the key functions such as oversight, complaint handling, and sanctioning powers remain unclear. This delay creates legal uncertainties for the data controllers and as well as the data processor as well. And the PDP law also imposes criminal penalties and administrative sanctions, but without institutional or procedural clarity and enforcement as it is remain unclear. But despite the law being enforced, implementing regulations remain in draft. The implementing regulation is expected to provide clarity and technicality on provisions under the PDP law, among others for the data breach notification, cross-border data transfer, and obligations to appointed data protection officers. So with the uncertainty, the risk for the data controllers now is twofold. The first one is under compliance due to vague standards, or over-compliance due to legal overcaution. And the next one is relating to the Child Online Protection Regulation, or COPR. In March 2025, Indonesia enacted the Government Regulation number 17 of 2025 on the governance of child protection in the provision of electronic service system, or COPR, and come into force in March 2025. The COPR applies to any electronic system that is either targeted at or likely to be used by children under 18. COPR introduces, among others, a clear age of children for digital users. And COPR is the first Indonesian cyber law that provides us a clear definition of the age of majority for users of electronic system, where those under 18 years of age are considered to be children. The second one is mandatory parental opt-in consent. The third one is risk assessment, including DPIA of products and services based on child exposure, age bracket-based verification, and strict rules on profiling, geolocation, and dark patterns. It should be noted that COPR is not a direct implementing regulation of the PDP law, though it imports several core data protection concepts. And the last one is relating to AI-specific risks and regulatory challenges. Currently, Indonesia does not yet have a standalone AI law, but momentum is building because the Ministry of Communication and Digital is currently drafting AI-specific regulation, which expected to be completed by the Q3 of 2025. These may take the form of a ministerial or government regulation. However, we have now interim guidance, which has been issued via the circular letter number 9 of 2023 on AI Code of Ethics issued by the Ministry of Communication and Digital, promoting principles like transparency, inclusivity, data protection, and sustainability. And the second one is sectoral guidelines, such as Financial Services Authority AI guidelines targeting on financial technology sector. So in short, Indonesia's AI governance remain fragmented with code of ethics, no legislation yet, and no binding enforcement mechanism. However, we note that Indonesia is progressing rapidly in data protection and online safety, but enforcement, infrastructure, and regulatory, especially for AI, are still works in progress. With that, I will let Duong to continue the presentation for Vietnam. Over to you, Duong.
Thank you very much, Andera. Hello, everyone. My name is Duong. I'm a counsel based in Hanoi office of Hogan Lovells, and I would like to give you an overview of Vietnamese regulations around data and digital space. So the Vietnamese government has been quite slow in establishing a comprehensive framework for governing data and digital related matters. It focused on specific modules at given periods of time. So the first area where the government tried to regulate was the security of online infrastructure, cybersecurity, and the government adopted a series of laws a few years ago, and only recently moved on to regulate data and digital content and data privacy. And the next step for the government will be to focus on applications of the use of data in areas like fintech and AI. So let me start with cybersecurity first. The government adopted 7 years ago, quite a long time ago, the law on cybersecurity, but it left it without an implementing decree, which was adopted only in 2022. So the regulations around this cybersecurity area is quite recent. The main purpose of this law on cybersecurity and its implementing decree is to protect national security, ensure safety of online communications, and deal with data breaches. To regulate online content, like there are regulations on mandatory takedowns of illegal content, and also, and more importantly, exercise control over data through the requirement to localize data storage. So in detail, this data localization requirement is one of the most probably concerning areas of regulation in Vietnam, especially for foreign investors. The regulation applies to all service providers in 10 areas, service areas specified in the decree. And the localization requirement applies when a service provider has not complied with a warning or request to comply with data protection regulations. So in principle, if there are no breaches and there's full compliance with data protection regulations in Vietnam, foreign investors are not, foreign companies are not required to localize data in Vietnam. But if there is a breach and there was a warning and there's no non-compliance, then foreign service providers will have to localize data and store data in Vietnam and establish a representation in Vietnam. The decree also provides for a taking down the requirement to take down all illegal content within 24 hours. So that's also a very strict requirement. Recently, the government issued a decree to further detail the requirements applicable to internet service providers and cyber information. So there are certain requirements that foreign entities will have to comply with: content moderation, user verification, and there's a special additional requirement to verify users using their phone numbers, and to notify the authorities about the provision of services to Vietnamese users. So this is for internet security and cybersecurity regulations. The government moved on recently to regulating data privacy and data. It issued initially a decree. The first document which was issued on data privacy was Decree 13, first to regulate in a comprehensive way data privacy in Vietnam. It took a lot of rules and principles from the GDPR, but it also has certain different approaches, adopted different approaches. For example, in terms of consent, there is consent exemptions. There is no legitimate interest exemption like in the GDPR. So the consent applies in all cases, most cases, and there are only certain limited exceptions for national security and public order where consent is not required. Decree 13, for the first time, mandates impact assessment filings with the Ministry of Public Security. Since this is for the first time this requirement has been implemented, there are still many difficulties, especially for foreign investors, in trying to comply with these regulations. There have been some guidelines provided by the Ministry of Public Security, but they are still very incomplete and sometimes contradictory, contradict the decree. Also, in the area of data protection, I would like to note that a recent decree 24 was issued to increase sanctions for breaches of data security regulations. But these are sanctions very focused on protection of consumer information. There's still no comprehensive decree or regulation on sanctions for breaches of generally of data privacy rules. So we are still expecting the decree to come. And as the latest development in the personal data protection space, the National Assembly of Vietnam is working on a draft decree, or draft law on personal data protection. The law is expected to be adopted at the end of this month, and will be effective early next year. It sets out, it confirms the general principles of Decree 13 on personal data protection, but introduces a much heavier sanctions regime. The penalties may increase up to 5% of the previous year's revenue. So this is quite high for Vietnam, and this is one of the areas which is hotly debated at the National Assembly at this stage. So we'll follow up and brief you when the law on personal data protection is adopted. The government is now, once these data protection and privacy regulations are established, the framework is established, the government will focus its attention on the applications of the uses of data And recently it adopted a decree for on sandbox, on financial sandbox, fintech sandbox. It will open new opportunities, new possibilities for enterprises, startups operating in credit scoring, open API, and peer-to-peer lending space. So I hope this gave you a broad overview of data protection regulations in Vietnam. You'll find more details in our guide. And now I'd like to pass the microphone to Charmian to discuss.
Thank you so much,
India.
Lo. So now we'll move on to India, which is obviously a very significant market in all of APAC, if not globally. And their most significant development with data would be the Digital Personal Data Protection Act, which has been enacted, but which commencement date we are still awaiting formal announcement of. We did see a draft set of implementing rules or regulations released for public consultation on the 3rd of January this year, and which closed in March. We expect that the final rules may be notified in due course. We just don't know when exactly. But these draft rules are intended to supplement the DPDPA by specifying procedures and technical standards that are necessary for compliance with the law. Earlier this month, in June, we also saw MAITI, which is the government agency that oversees data protection, release a guide on consent management under the DPDPA. So we see active steps essentially being taken to progress the advancement of the DPDPA coming into effect. To recap, key features of this law include, number one, a distinction between what we call data fiduciaries and significant fiduciaries. So fiduciaries are essentially data controllers, and there are heightened obligations if you are of a significant, classification, which means you process, a higher volume or sensitivity of personal data in India. So your obligations will include having to appoint a DPO, conducting, data protection impact assessments, and maintaining records of processing activities, for instance. And also under the DPDPA, they are looking to establish and set up a data protection board to specifically administer and enforce the DPDPA. In terms of extraterritoriality, I thought we would talk a little bit about that. It's akin to the GDPR insofar as data process, is outside of India, but and will still be covered by the law. But there is a distinction. So it's only if the processing is done with the intent to offer goods and services to individuals within India. So firstly, it doesn't cover profiling, right? Like in the GDPR of data subjects, from outside India, especially if it's not in connection with, any kind of goods or services being offered to them. And then secondly, and this is unique and important in exclusion for India, and I think it takes into account the fact that India is very much a business process outsourcing hub. Foreign individuals' data that is processed in India is totally exempted from the Act. On cross-border transfers, India's DPDPA adopts what we call a blacklist approach, which means that transfers are generally permissible unless to a specifically blacklisted jurisdiction. And I think we generally expect that this will be guided at least in part by geopolitics. Consent is the primary legal basis for processing in the DPDPA, and we flag here that, in India, there are 22 gazetted languages, which means your notices and your consents technically need to be provided in 22 languages. There is also a legitimate use alternative basis for processing, for employment type processing, etc. But do note that this is different from the legitimate interest basis that we are probably familiar with under the GDPR. Data subjects or principals, as they call it in India, have similar rights to those in the GDPR, and there will be mandatory breach reporting of, again, 72 hours, similar to the GDPR, but which will need to be reconciled, we think, to some degree, with the pre-existing 6-hour reporting rule that CERT-In has in place insofar as personal data is implicated. So next slide, please. And this will be the final jurisdiction across all of APAC, Australia. We end off with Australia as the last, but certainly not the least. There is a ton happening in Australia as well. Firstly, with its privacy law being amended in December 2024. Key changes include the introduction of a new statutory tort for serious invasions of privacy. So this is where aggrieved individuals can bring lawsuits against infringing persons where the alleged conduct is intentional or reckless and causes serious invasions of privacy. And I think this kicked in yesterday. There is also a new criminal offense for doxing, and I think there is similarity with Hong Kong, for example, with regards to the deliberate sharing of personal information with the intent to harm individual persons. And this is punishable by up to 7 years imprisonment. The ceiling for civil penalties for infringements of other privacy breaches in Australia has also been raised, and now the ceiling is at 50 million Australian dollars. And by the way, these, increase of, financial penalties is a bit of a common thread across APAC, where, we are seeing a tightening of sanctions, a raising of financial penalties as our laws in this space mature. Australia's Information Commissioner's office has also mapped out plans to introduce a children's online privacy code by December 2026. So we see again a bit of a trend across APAC with regards to children and online safety. This is different, by the way, from Australia's widely talked about social media restrictions that essentially prohibit children under 16 from using social media. But instead, this online privacy code will regulate social media platforms, messaging apps, and other designated internet service providers to ensure that they accord special protections for kids who use their services. So this is all going to be consulted extensively upon, but is very much in the works. With automated decision-making, there are now transparency obligations in Australia that require specific disclosures in privacy policies, for example, that such decision-making is happening through or using automated processes. And with regards to AI in particular, we saw 2 privacy-centric guidelines being rolled out last year, one for developers and one for businesses that use commercially available AI products. We also saw a pretty novel set of model clauses with third parties, which actually deal with public sector agencies, but which would be helpful, as a reference point for any kind of private sector businesses, we think, and which we're blogged about in our Hogan Lovells Our Thinking page. So if that is of interest, do remember to subscribe to our Thinking page. Finally, and this is a very interesting development off the back of a couple of major data breaches that happened in Australia recently, we have seen Australia become pretty much the first country in the world to make it mandatory for an organization to report a ransomware payment. In other words, there are sanctions for an organization that receives an extortion demand and does not inform the government within 72 hours. So this is, I think, needless to say, very illuminating, and we will wait to see if other nations, including in APAC, but also globally, decide to follow suit. And with that, I'm handing it back to Tommy to wrap us up.
Thank you, Charmian. As everyone can see, the recent development in the APAC region, these data protection laws and cybersecurity regulations have been suggesting there is a significant cross-region movement towards the GDPR standards, but in a way that leaves room for important local variations in data protection policies, cybersecurity requirements, reflecting each individual jurisdiction's specific policy goals across a wide range of areas. There are areas which touched upon, including consumer protection, human rights, national security, and also reflecting economic developments. So the organization's data protection compliance programs should take a strategic direction from the accountability-driven model championed under the GDPR. The points of compliance for organizations are required to manage under the disparate laws, including data subject consents, notifications, exercise of data subject rights, and the satisfaction of mandatory breach notification obligations. With APAC region and data protection standards on the rise, and with lawmakers now showing great resolve to punish those who fail to meet the mark, multinational organizations have a good reason to develop a coordinated regional strategies for compliance. The smart data protection compliance APAC requires also on a local basis, a local review. It requires a regional review, given there is significant efficiency to be gained from developing a compliance program for APAC that reflects the rising high watermark and so avoids reinventing the wheel for each market. And thank you everyone for joining today. Next slide, please. We'd like to share, next slide, please. We'd like to share, previous slide, my bad. For those of you who have joined the session, please ensure you scan the QR code on the top right-hand side to complete the online evaluation form. This is required by the Hong Kong Law Society for your CPD points. I will stop here for 10 seconds. And if anyone has any questions, feel free to raise or type it in the chat box. We are happy to address, noting we only have 2 minutes left. If there's not enough time for us to respond to your question here, you're always free to send any emails to any of us here. The APAC team of Hogan Lovells is always willing to support you and share our thoughts with you anytime. Next slide, please. The last one, we have a small advertisement. This is the Hogan Lovells Digital Transformation Academy. It offers and explores the multi-faced legal, regulatory, governance, and enforcement challenges that arise across the many technologies and trends in the digital age. So scan the QR code and join us. I do see there's a question. Sorry, let me see. Oh, there are a lot of questions actually. But I don't think we have time to respond to them one by one. But our team is taking the questions in writing, and we will respond to each of you after the webinar. So I can see there are 4 questions here. These are duly noted. We will provide responses to each of you after the session. Actually, there are 6 questions, sorry. So yeah, we will do that. Thank you very much for your time. And I guess that's the end of the session today. Thank you very much. Thank you.